Hi, everyone, and welcome to Raw Law. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and we are live to answer your questions and to talk about your comments. So feel free to join us. Join. You could jump in the chat, leave a comment or your question, and I'm happy to answer it live. So let me see. I didn't schedule this particular call. I kind of just wanted to do one because I don't think I'm going to be able to do one tomorrow. We're coming up on the Thanksgiving holiday. And so because of that, I thought I would do one today just to get one in this week so we don't miss one and not have one at all this week. And I've been doing a few consult calls today. I think I spoke to 2 or 3 people. And I'm going to do at least one more call later today and then maybe a few more tomorrow as well. So yeah, so feel free to drop your questions in the chat. And meanwhile, what I'll do is I will go into the channel and maybe answer a few of the comments in the channel just while we give people a chance to join. Let's see. Here's a question from about 2 days ago. And it says, in my deposition, they tricked me and they asked the same question. What cannot or what can't you do now that you could do before the accident? And yeah, so I mean, that's not really, I mean, that could be, that's not really a trick. What they want to know is they want to understand like how the accident affected you, right? How the accident changed your life, the effect that it had on you. So essentially, they're just asking, like, what are some of the things you were able to do before that you can no longer do now? So it could be like physical activities, right? It could be, you could just think of, for example, like I was able to do things with my spouse. We were able to go out and, go out to dinner, sports, work. And now I can't do it for whatever reason, right? Because I'm injured, because I just, I'm depressed. I have my depending on the type of injury. Some people have a TBI, so I have a brain injury, so I just can't do the type of processing or analytical thinking that I did before, whatever it is. So just, that's the best way to answer that. But sometimes, yes, sometimes the lawyers in the deposition that are representing the defendant, what they'll do is they'll ask you the same question, like multiple, ways. Especially if they don't like your answer, they might throw it at you a little differently. But so your lawyer has to be there defending you. That's what it's called. It's called defending a deposition. So if they hear the same question being asked and you've already answered it, they have to object and say asked and answered. So that's very, very critical. That's the other part of it. He was saying that he gets the same question many times. Okay, here's a few questions. Sergio is here. He says, hello, I have a question. Yeah, feel free. Ask away. Gatry is here. Hello, Arkady. Happy Thanksgiving. Oh, yeah, happy Thanksgiving to you, to everyone. Happy Thanksgiving and have a happy holiday. And then the one says, is a video deposition a bad thing? No, not at all. In fact, like I love to do video depositions of defendants because the beautiful thing about video depositions is that, you records everything, right? So it's not just a question and answer like you get in a boring old transcript, and you have everything. You have their mannerisms, you have if they're like pausing or if they're, nervous, or if you could tell sometimes, there's a lot of different things. Basically it's the same as a trial. So then what happens is if you take a regular deposition of a defense witness, let's say, and you just have their transcript, then at the trial, when you cross-examine them, you could of course impeach them, right? If they say something that's different from what's in their deposition, you could say, isn't it true that back on June 5th, 2017, you were asked this question and you gave this answer? And then you read the question and you read the answer, and it's different from what they're saying in court. But if you have a video, you could edit the video and you can create splices. So you could actually ask them a question. Like, for example, you're asking them, isn't it true that you knew about this hole for a whole year and you never fixed this hole that caused my client to fall? And if they say no, then I say, oh, yes, well, don't you remember on June 5th, 2017, you were deposed And then you just play it. And then you ask, hey, well, did you know about the hole? And they say, well, yeah, we've seen that hole before, or whatever, whatever the impeachment is. So it's so much better, right? You're playing the actual video. So, and for plaintiffs, I think it's fine too, as long as your lawyer preps you and you're ready. So they have your video, big deal. What are they going to do with it? They're not really, I haven't really seen defense attorneys impeach plaintiffs with a video. And in any case, the fact that you are going to be available at trial. So, because usually the deposition can only be used instead of you testifying if you're not available, right? If you're like in another country or passed away or whatever. But if you're available, they could only use it for impeachment. So as long as you're not saying anything completely different from what's in the deposition, you should be fine as a plaintiff if they're asking to videotape it. Leonardo is here. He says hello, and come along with Uncle Joe says good evening. Hi, how are you? And then baby boy Jody is here. He says, hey, buddy, why is my case taking so long? Baby boy Jody. Who's baby boy Jody? I don't know. We gotta look into your case. The best thing to do. Oh, he asks, I see. Hey, buddy, I was hit by a truck with a $3 million policy. I got a 3-level neck fusion, my hip, so I had to get another hip replacement. How much can I get? I was packed. I think I was parked. Probably you mean parked, right? Well, that's a good case. I mean, look, if it's a 3-level fusion and the truck has $3 million, it should be all of $3 million. I'd have to know a little bit more, like what city you're in, and a lot of all the information. So just text me 347-566-9595. I'm happy to chat and help out. And then Renee says, good afternoon. I like your live videos. We all appreciate all your advice and information. It really helps. Oh, you're very, very welcome. Thank you so much. And the one says, hello, how are you today? No, I'm doing very, very good. And Renee says she's glad that her phone went off to catch the live. Oh, that's awesome. Yeah. Yeah, I didn't schedule this one, so this is kind of like a last minute one. And let's see. Oh, the one asks, once the deposition is done, what's the next step? Right. So after the deposition if it's the plaintiff's deposition, they're still going to be deposing the defendant, and they may depose a few other witnesses like non-parties. There could be some post-deposition discovery, like after depositions of all parties, there could be additional documents that you want to ask for that you learn about by asking questions in the deposition, right? And then once all that is done, then all discovery is done. Then you put it on the trial calendar, you file a note of issue, and then you wait for the trial. But while you wait, you have settlement conferences and compliance conferences, and you could settle the case. And if you don't settle, then you end up going to trial. So that's usually how it works. And Malicia Designs says, hi, do you ever hear about attorneys filing suit prior to any demands in Michigan? Yeah, I mean, if the case is really serious, there's not really a reason to make a demand, because a lot of the good trial attorneys know that you're not going to get, like, say it's a serious case, right? It's a truck crash, like surgeries. There's no point to call and try to settle, like because pre-lit, in the claim stage, they usually pay relatively low numbers. So a case like that, you want to file a lawsuit. So yeah, you could do that. You could file a lawsuit without doing the whole demand and offer song and dance. You don't have to go through that. And baby boy Jody says, this is in New Jersey, Atlantic City. Yeah, just text me. I'm happy to chat. Maybe I could do a call with you tomorrow or next week. Yeah, absolutely. That's what we're here for. We're here to help. And I do a lot of these consultations for truck accidents, and that one sounds like a great case. And I actually know a lot of the trial attorneys in New Jersey that are really good, that get some of the top numbers. In fact, one of them that I work with, I think was president of the American Truck Accident Attorneys, which is like the biggest group nationwide for truck cases. So yeah, I might be able to give you some recommendations if you need like a second opinion or whatever you need. I'm just happy to help. And then one shot. Leonardo says, what's the difference between adjourned and continued? Yeah, it's not really any difference. It just means they're putting it over for another date. And then one chat says, "Hi, Arkady, Anthony here about our chat. No rush, great video." Yeah, absolutely. We're going to do that. I think I'm not sure if it's the same Anthony. I was supposed to do a chat later today with somebody. I think I have it. I have it in my calendar. Don't worry. I'm going to call. I'm going to call. In fact, I'm looking at right here. I'm going to call later, maybe after this. I'm going to do it. Yeah, Anthony. I'm going to call after this. So don't worry. Absolutely. And then let's see. James says, "Hi, how are you doing today? Very good. Thank you for being here. Great to see you." And Brandon says, "Hey, I'm in Florida. How long does it take to file a lawsuit when your lawyer files it? Is it electronically, which is instant, or does it have to be mailed? And if it's filed electronically, how long before?" So yeah, in Florida, I think, I'm not sure, because I'm in New York, but I think you can file it electronically in most places, most states. I'm not sure if there are any states that still want you to do it the old school way where you have to like walk it into the courthouse and have the paper copy. I know federal courts are all electronic. They have ECF, electronic court filing. New York has it. It's called New York State Civil Electronic Filing, NYSEF. We call it NYSEF, but it's New York State Civil Electronic Filing. So I'm pretty sure it's electronic in Florida as well, like 99%. But I would ask a Florida lawyer. And he says, "How long before the insurance company is aware of the lawsuit?" Right. So that's different. When you file it electronically, it just gets filed in the court. Now, the insurance company, for them to be aware, what you have to do is your lawyer has a process server, and that process server serves the defendant, the person you're suing, right? So then the defendant now has the lawsuit. The defendant gives it to his insurance company, like Allstate, Geico, whoever. Then they have 30 days to answer. They give it to their lawyer, and their lawyer, appears in the case with an answer, and that starts the case moving. It usually takes about 30 days or so. And then the one says, "Thank you very much for answering my question." "Oh, you're very welcome. I'm happy to help." And Mario says, "Around how much is TMJ injury usually worth?" Oh yeah, that's the injury with the jaw, right? That's like a jaw injury, TMJ with dental. It's hard to say. It depends on the extent of the injury. I'd have to do some research into that. But the ones I've seen, if it's a real serious TMJ, it could be worth some money. It could be worth some money if it's real serious. So it just depends. But it could be anywhere from like 50 to 75,000 and up. It could be much, much bigger if it's more serious. And then Amiri, "How long does it take to get a response to a settlement opportunity letter?" Usually it's 30 days. So yeah, if you write it the settlement opportunity letter, they have 30 days to put in an answer. And Baby Boy Jody says, "What's your number?" Oh, sure. It's 347 566 9595. I'll drop it in the chat as well. You could just text me, and then we'll schedule a call. If you text me, just let me know a little bit about your case, like what happened, the brief facts, the injuries, your name and your city. Like for example, got hit in the rear. I'm in Dallas, Texas, and I have ACDF, right? That's enough. Just a little. And then my name is John or whatever. You can give me your whole name or just your first name, and then we'll schedule a time that's mutually convenient. That's good for you, and I'm happy to call and do a consult. And then Lakeisha says, "Hello, I had a ceiling collapse while I was pregnant. Do you think this is a good case? I have a bulging disc and a herniated disc in my lower back and neck. This happened at a hospital." Oh, wow. Hospital. That's crazy. Yeah, I think those are good cases. Like ceiling collapses, I handle a few of them here in New York. They're usually good cases because, ceilings shouldn't collapse. As long as there's some kind of notice, like for example, like at a hospital, I'm not sure, right? Because we still could prove it, but we'd have to find out about their repairs and what was happening with the ceiling before. But usually it's in someone's apartment or in their house. And those, you kind of just look up at the ceiling. Hey, there's a crack. I complained about the crack. I wrote an email. I sent a text. The super never fixed it. Some time passed, like a few months, 2-3 months. They should have fixed it. Or they tried to fix it. They just kind of patched over it, but they didn't do a proper fix. They didn't do a good job. And now the whole thing collapsed. Those are good. Oh, she said New York City, Brookdale Hospital. Oh, yeah. But that could be a great case. Yeah, just text me. I'm happy to help with that. The same number, 347-566-9595. I'm happy to help. Yeah, those are good cases. I mean, I haven't done too many against hospitals, but it doesn't really matter the building. The point is that it shouldn't collapse. The ceiling should not collapse. And Mario says, do the drivers at fault for an accident get alerted by their insurance if they're getting sued? Yeah, so no, it's the opposite, right? So the drivers get served with the lawsuit, because when you file a lawsuit, you're suing the driver. Let's say like John Smith rear ends you. So you sue John Smith. Then the process server comes to John Smith and says, John Smith, you're being sued. You're served, and they give him the paper. And the paper says, your name, like Bob, whatever, against John Smith, right? So you're suing, or Mario, Mario against John Smith. You're suing this guy. So then John Smith has to take the lawsuit. He's got the lawsuit now and give it to his insurance, whoever it is, right? Like Progressive, Allstate, Geico, and then they then assign a lawyer. They might have in-house counsel that always defends all their cases, or they might use a law firm, like a private law firm that they have a deal with. And then that law firm then appears in court and says, we're the lawyers for John Smith. But really they're the lawyers for the insurance company. But that's how it works. So yeah, it's okay. And then James says, how long does it take to have a deposition in a slip and fall case at a convenience store? So do you mean how long does the deposition itself take? Or that depends on the lawyer, right? Some lawyers might take an hour. Some lawyers might take 7 hours. It just depends on the lawyer. And also how bad the injuries are in the case. Or do you mean like how long does it take to get to the deposition? That also actually depends on the lawyer, right? Because if a lawyer is really efficient and files a lawsuit right away and does, like, depending on where you are, like in New York, we have a bill of particulars. We have to list all the injuries in the pleadings, answer some of their questions, file an RJI, a request for judicial intervention, and then schedule and hold the deposition. But, some lawyers might be lax. They might get the demand for what's called a BP, a bill of particulars. They might just sit on it for like 3 months. Well, then you're going to wait another 3 months. If you sit on it for 6 months, you wait another 6 months, So, but if you answer it right away, have strong paralegals, like we have a team here. We have 25 people. We have paralegals, other attorneys. So it's not just me, it's me, but we have a team. So we do that quickly. And then we get the deposition scheduled. So, but yeah, if you sit on it, of course, you could be waiting a year, right? It just depends. But yeah, so I guess both questions depends, but it shouldn't be too long. It shouldn't be too long at all to get a deposition. I mean, the way I do it, usually if you file a lawsuit to get to depositions, it could be done in a few months if it's litigated aggressively. Okay, and then Steven says, what happens if a truck driver that was at fault for an accident cannot be found when litigation starts? The company cannot find him. Yeah, it doesn't matter. I mean, like, as long as you know what happened and you sue him and you sue the truck company, if he no longer works for them, he might be gone, right? He might move to Europe or Australia or whatever. Some people, pass away, whatever. Or he might just, be gone, whatever. Who knows, right? He might be like walking the Great Wall of China or whatever. It doesn't matter. You don't need him. Like, if he's not available, as long as he gets or somebody gets served, duly served, or attempted service, and you serve the company, and then once it comes time for depositions, they have to produce the driver. If they can't produce the driver, he gets precluded as a matter of law. So then it's your version of how the crash happened versus no version at all, because there is no other version, right? Because the driver of the other vehicle is not available. So that's you win basically on liability. So you still have to prove your damages, your injuries, but you win on liability because it's you versus nobody. So it's actually good for you, if he doesn't show up. And that happens a lot because with trucks, people leave, people get fired, people are, say they leave that trucking company, that they used to work at ABC Trucking, they hate you. Now they work for XYZ Trucking. And then the ABC Trucking calls them, they don't even want to answer because maybe they're making money with XYZ Trucking, they just forget it. Or whatever, right? It's life. There's so many possibilities. But basically, yeah, you don't have to find him, you just have to attempt to serve him and serve the trucking company. And so that's pretty much And Lakeisha says, how long do you think it takes to settle? So, I mean, it's hard to say. It depends on how the case progresses and depends on the injuries. If the injuries are relatively small, like I think you said, just a bulging, if it's just a bulging disc, soft tissue, no surgery, you could probably settle it maybe even in a few months. If it's something more involved where you have like a back surgery, something bigger, then, it makes sense to litigate. It might take a year, 2 years, but you're going to get much more money. So I think a lot of that depends on the injury. The bigger the injury, the more money, but then it also takes longer because you have to go through all the steps it's like a process, you have to go through the whole process, the whole timeline. So. And Brandon says, I was rear-ended. The policy is 1.5 million. I have 2 herniated discs in my neck and 2 in my back. I've had multiple procedures plus a percutaneous discectomy on my neck and 1 on my back. And my treating doctor says I have permanent injuries. I'm only 35 and my lawyer sent a settlement opportunity letter. The insurance company responded with $100,000, which my lawyer denied. The insurance company said they have to look into a 2020 accident that I had. So a prior accident. Yeah, they always look at prior accidents. And so the lawyer's filing a lawsuit. Okay, that's good. That's good. Yeah, I would file a lawsuit on that. If you're looking for a big number, like, you have 1.5 million and they're only giving 100,000, you better file a lawsuit and get the maximum on that. And Lakeisha says, do you think it will be a long, drawn-out case? Well, no, not necessarily. Like if it's just a bulging disc and it's like soft tissue or bulging disc with some injections, I think those could be settled fairly quickly, maybe even in a few months. If it's something more, like I was saying, like with a fusion, it doesn't have to be drawn out, but it might take a little longer. I want to be honest. But then you're looking at a completely different case. Like, a fusion cases could be like, we just settled one for like 2.2 million last year, 3.5 million. So they're much bigger. They're usually in the millions. But, so it just depends on the injury. James says, how much is a total knee replacement and damage to my other knee for compensating for the one that was injured? Yeah, that could be big. Total knee replacement could be into the millions, as long as the insurance is there, as long as there's enough insurance. Absolutely. And Dobby says, rear-ended by a semi-truck. The truck was 100% at fault. It happened 6 months ago. I've been getting medical treatment. The lawyer is moving slow. Should I expect something faster? It's hard for me to say. Text me, 347-566-9595. Happy to do a consult, maybe speak to you about it and, let you know. And, I could give you some advice. I could even, if you tell me who the lawyer is or the law firm, not here, but like when we do the private consult, I could even do a search and then send you back all their verdicts and settlements, and you could see for yourself what kind of results they've won. I mean, sometimes people ask me and I do it and the results are good. Somebody's won like $1 million and that's what you're looking for. You're looking for $1 million, so that's good. But other times it's like not so good. Like I think this week somebody was asking me, hey, can you do it? And I did it. And the highest result was like something like just a few thousand, like 12,000 or something. And a lot of them are like 2,000, 3,000. He's like, well, what's going on? I don't want 2,000 for my case. So, you don't know what you don't know. So it's good to like look into that and just so the consumer, right, the injury victim, so you're educated and you know what's happening with your own case and your own lawyer. So yeah, absolutely. And then Steven says, can you talk about different adjusters for different demand amounts? Different adjusters. So there's a pre-litigation adjuster, that's before you file a lawsuit in the claim stage. They usually have authority only up to a certain amount. Then once you file a lawsuit, they switch it to a litigation adjuster. And even then, when you're litigating, say you go to a mediation, they might say, okay, I'm the adjuster, I'm at the mediation, I see you, I see the judge, but I only have authority up to a certain amount, like 500,000. If you want more than that, I have to call my supervisor. I have to get a different level of authority. Then they have authority for like up to, 1.5. Then if I want more than 1.5, I got to call the. So that's how they work. They always have like levels, levels of authority. I guess they're afraid of like giving away too much money. One person's going to say, you know what, I'm feeling generous today. Take 10 million. So they don't like that. So they give you authority. Oh, you have 500, you have the next 500, you have the next million, you have the next, that's just how they work. So, but yeah, usually you want to talk to the real money person that can, has the high authority if you have a big case. And Leonardo asks, when it says continued a conference, does that mean it took place or not? It's hard to say, you'd have to be there. Sometimes they could mark continued. I guess it should be that it was held, right? Because it started. I mean, the way that the word is defined, right? If you just look at the definition, continued means something started and didn't finish, so you're continuing it. But it's hard to say, sometimes they could just put continued because, just the clerk puts that. So it just depends on which word the clerk chooses. It's not really, I wouldn't really focus on that. It's not important. They could choose adjourned or they could choose continued. They could just choose whatever. It's not really material. It's not important. But yeah, it should be, according to the definition, it should be held, but maybe it wasn't. And if it wasn't, then you just have to, it's going to be held on the next date. And then Brandon says, worried about the 2020 accident because I never got treatment besides going to the hospital that night. Also, I have videos of working out at the gym. I haven't been to the gym since my 2023 crash. So you mean you have a prior accident, right? The 2020? But if you only went to the hospital for that prior accident, why would you be worried about it? It would be bad for you if you actually got a lot of treatment and you had a lot of injuries from the prior. Because now you're talking about suing for the 2023, right? Which is the one you have now. So the prior one, if you didn't treat, then it doesn't hurt you. It doesn't matter. It's like it never happened. So I wouldn't worry about that. Why? Maybe I'm not following, but I don't think that you have to worry about it. A prior injury, it only like comes into play if like you had a prior and the injury from the prior is the same as the injury you have now, because you can't sue now for what you already had, right? Like say 3 years ago, 2020 versus 2023. But like if you just went to the hospital one time, you didn't get any other medical care, well, then it's like you didn't really get hurt from 2020. So the fact that they get the records, what are they going to see? That you got into a little fender bender? They can't prove anything. There's no MRI. There's no diagnosis. You just went to the hospital once and you were treated and released. So that's good. So it doesn't affect you at all. So I would just focus on the case you have, which is the 2023, right? The one you have now, and it should be fine. Okay, let me see. What other questions do we have? James says, I had one surgery on my knee already, and I got to go back in for a total knee replacement. And yes, I'm in New York. Oh, okay. Yeah, total knee replacement. I mean, those could be big cases. I would just find out how much insurance there is. And depending on the type of case, sometimes they happen with slip and fall. Sometimes they happen with truck accidents, whatever the type of case. But that could be big. Those could be. I settled a total knee. I think. What do we get on the total knee? We just settled one, 1.25. I think 1,250,000. That was the one where a guy was working in a building, and he tripped and fell because they left like this step, like one of those like steps that's, I guess you could move it. It's like wooden, and it's like 3 steps. But it wasn't attached to anything. So he doesn't know, right? It looks like a staircase, like 3 steps. So he starts walking on it, and the whole thing like falls over because it's not attached to anything. There's no handrail, nothing. So it's just a dangerous condition. And he ends up getting a surgery, like total hip replacement. And you're talking about total knee replacement. He had a total hip replacement. Well, it's similar. Total replacement of anything is pretty bad. We had a total shoulder or elbow replacement a few years ago. I think we got almost $2 million on that one. This one was a total hip. We got 1.25. But a total knee, I would say, also is about 1.25, 1.3. It could be pretty significant. Yeah. And then Mighty says, how long does it take for you to settle a fusion case? It depends. Like they're all different, but I would say a fusion case, it depends on the policy. If the policy is relatively not that big, right? Let's say they have $1 million policy. Well, I could just send a settlement opportunity letter And if the liability is clear, like a hit in the rear, file a summary judgment motion. So I say, look, pay me the $1 million, because if you don't pay me the $1 million now, well, then I could open up the policy and go for bad faith, right? Or I'm getting 9% interest on the summary judgment as well. So you're just going to pay more later, and they don't like that, so they'll pay. But if it's like a different kind of case with, like, say, a fusion, but the policy is really big, like 10 million, they might try to save money and offer less, like offer like 300,000, and then you have to go through court, and then right before trial they might offer you like 2 million, 3, whatever it is, and then you have to go to court, go to a jury trial to get like the top number. So but yeah, it usually takes, usually most cases take at least a year or two if you're litigating. Okay, and then Russ says, my lawyer beat Allstate 100%. I had dash cam. It was a hit and run. The lawyer is going after my own UIM C4, C5 tear in the disc. Myself and the other driver both had Allstate. Thoughts? So liability is good, so that's good. Dash cam is good because you could show what happened, right? So you get liability. And then the lawyer is going after your own under insurance or uninsurance, right? And you have a C4, C5 tear in the disc. That's pretty serious. Yeah, depending on how much the limits are for the UIM, you can probably settle it, or if you have to go to like a hearing and arbitration, you should be successful. It seems like a pretty clear-cut case. And then Lakeisha says, can we get a different lawyer during the case if I can't ever get in touch or communicate about my case? Yeah, absolutely. That's up to you, really. It's like, you go to a doctor and you kind of think, yeah, I don't know about this doctor. Then you get a second opinion with another doctor, and say the second doctor, you say, I love this doctor. I want this doctor to be my doctor. If I need a surgery, I want the second one to do it. I don't want the first one to do it. So it's just like that. Same with lawyers, right? It's just freedom of choice. Like today, I want Pepsi, but tomorrow I want Coca-Cola. It's like you can do whatever you want. The only time you really can't switch lawyers is like if you have a trial like tomorrow, or like in a month. It doesn't really make sense because like the first lawyer is entitled to all the legal fees already. So the second lawyer just economically may not step in because he's going to say, well, the first lawyer already did everything. I can't change anything. And also, I can't really, it's a little too late. But otherwise, you could absolutely do it. Absolutely. You could absolutely do that. And let me see. Russ says, thank you for your time. Oh, you're very welcome. And Amiri says, is no response to the demand letter a bad sign? No, it's not necessarily bad. It's actually, sometimes it's good, right? Because if they don't respond, then what you could do is you could open the policy so you can get more. See, like, for example, if there's a small policy, like 25,000, and you send a settlement opportunity letter, hey, pay me the 25. If they pay the 25, okay, you got 25. But if they don't pay the 25, they don't respond, well, now you could say, well, okay, thank you. You had your chance. That was your opportunity to settle for the 25. You blew it. Now I'm going to a jury. I'm going to get $1 million, and the policy is open. You're going to pay me the full $1 million. So, it's not really a bad thing at all. Like I said, in some cases, it could be a good thing. Oh, actually, I have to take a 1 second break. I'm sorry. I'll be right back. Maybe like in 2 minutes. And then I'll leave this here. I'll be back and then we'll finish up. I just have to take a break to do something. Someone is here at the door, so I have to go check. Sorry about that. I'll be right back. Oh, okay. Sorry about that. I'm back. Sorry about that. I just had someone at the door, so I had to like go and help them for a quick second. Delivering turkeys. No, I'm just kidding. Okay, let's see. What other question? Where did we? So we did the one about the response to the demand letter, right? So that's not necessarily bad. Oseni says, when a small car has 100,000 as a limit, does it mean that it's highly likely they have umbrella? No, if they have 100, they probably don't. 100 usually doesn't carry umbrella. Usually like 250 does or more, right? So like with 250, you could have, like I have cases with 250 with a million umbrella or more than a million, but 100, I haven't really seen too many with 100 with umbrella. In fact, one time an insurance adjuster told me, like off the record, he said, look, if it's 100, it never has umbrella. Because it just they don't write umbrella for 100 policies. But I guess I don't know if that's necessarily true, right? Because you could have, let's say, 100, and then you can go out and just buy like a general umbrella from a different broker. So you always want to look into all the possibilities, just to be safe. Okay, and then Tim says, was diagnosed with PTSD and severe depression after an accident with a semi-truck bobtail. The semi-truck was totally at fault. Possible settlement value. Yeah, I mean, that could be big if it's worked up properly, right? If you have true PTSD and it's worked up the right way. Like I know lawyers that really, they work up. I've done videos on this, like where I talk about the fact that PTSD can be as valuable as a traumatic brain injury, which, could be millions and millions of dollars, but it has to be worked up the right way and prepared the right way. So, but there are certain lawyers that know how to work up PTSD to the point where they can make it into a multi-million-dollar case. And then Melquan says, would it be financially wise to get a 2-level post and anterior fusion cut from the front and back, and the policy is $500K? It's hard for me to say. You never want to do any kind of procedure just for financial reasons. You want to only do it if you need it medically, because that's a serious thing. It's your body. So if you need it medically and the doctor says that, hey, you're going to have it anyway, then you might as well have it like now, right? But you can get 500,000, let's say, for it, as opposed to settling the case for like 20,000 or whatever, and then getting it like 5 years later, but then no one's going to give you any money. That doesn't make sense, right? So it's really up to you and your doctor. But yeah, if you really truly need that, but I would maybe get a second opinion or even a third opinion, because that's a serious surgery going in from the front and the back. So if there's another surgery that's less invasive, that you could solve your medical issues, maybe think about that. That could be better. And then Alex says, I'm 6 months into my case from day of accident. My lawyer filed a lawsuit against both commercial vehicles involved in my accident. He said I should be doing a deposition soon. Is this a good sign? Yeah, that's a good sign. A deposition. I mean, it's not really like a sign. It's just like part of the process, right? So it's like, step 1, step 2. It's like it's a baseball game, right? It's like saying I'm in the second inning of my baseball game is not a good sign. Well, it's good. It's better than being in the first inning, I guess. It's just like, it's a step. It's one of the steps that you have to go through. Like, just like in a baseball game, you have the second inning, you have the 9th inning, that's the final, right? So it's the same thing. But yeah, if he can get a deposition within 6 months, that's pretty good. That's actually pretty good from date of accident. So he filed a lawsuit and he's got 2 commercial vehicles and he's doing a deposition already. I would say just from it's hard to say, right, without doing a consult. So like I said, if you want a consult, just text me, the 347-566-9595. But just from the comment, I think it is a good sign. If he got a deposition within 6 months, that's fairly quick. And then Bernard says, Eggshell rule, just had posterior cervical fusion 3-level to fix a broken anterior fusion from 2 years ago. My attorney has the case. Does the Eggshell apply in New Jersey? Yeah, absolutely. I think the Eggshell rule pretty much applies everywhere. It's just, the idea that you take your plaintiff as you find him or her, meaning like, it is what it is kind of thing. If you hit somebody who's in perfect shape, right, like really like a bodybuilder, whatever, Mr. America, okay, you hit him. He says, it's just a boo-boo. It's nothing. He keeps walking, keeps running, goes to the gym and bench presses or whatever they do, right? But if the same thing happens, but now you hit an 80-year-old, right? The 80-year-old falls over, their brain splatters on the concrete. They have to have 5 brain surgeries. One case maybe is worth 0. The other case could be worth like 10 million, right? But it's just, you take your plaintiff as you find him. You can't say, so yeah, I think it applies everywhere. I don't think there's any place where it doesn't apply. Okay, and then Thomas says, hi, Arkady, I was rear-ended. I had a bleeding brain. I had surgery. We did mediation before 1 month. Insurance didn't settle. They only gave a lowball offer. I'm waiting for physical therapy, PT. Oh, no, I'm sorry to hear that. That's a serious case. That's really serious. Oh, he's waiting for pre-trial. Okay, yeah. No, that's a serious case. Yeah, also, just text me. I'm happy to chat. 347-566-9595. And Lady L says, what would the case be worth if you have a wrongful death, negligence, medical malpractice in New York public health law, and you pass summary judgment and all counts, and you pass the argue? I couldn't really tell you, right? Because to tell you value, I would have to know like what the injury, I mean, you have wrongful death, right? But I'd have to know like how the wrongful death happened, like the facts, right? Because just saying like, negligence, medical malpractice, those are just types of cases, right? There could be like 100 different medical malpractice or 100 different negligence cases. So I couldn't really tell you, but public health law usually applies to like nursing homes, like bed sores, failure to turn, those residential facilities. Yeah, those could be, those cases could be anywhere from a few 100,000 even into the millions. I've had a few of those cases. We've done really well with them. So, and then 777 says, blessings, can your firm draft papers for a fee? We don't usually draft papers. We usually just take the whole case and do everything. But yeah, depending on what you need, just let me know. And then Sandy says, how's it going, Arkady? Hope everything is going well. Hi, how are you? Yeah, everything is good. And then someone says, hi, Arkady. And Lasito says, I'm having 6 weeks of physical therapy for a labor law 240. Yeah, labor law 240. Those are good. Those are great cases because it's basically, if it's a real 240, then you get liability automatically, meaning, it's 100% liability. So those are good cases. And let me see. Oseni says, can we open the policy if they don't respond to a notice to admit? No, to open a policy, you have to do the settlement opportunity letter. But in New York, it's tough. Like the laws in New York are different. So you might not be able to open a policy in New York. And then Eva Love says, I have a question. I was walking in front of someone's building and I tripped over a gas and exposed gas pipe. I was 7 months pregnant at the time due to the slipping, but I delivered the baby early. Do I have a case? Possibly if there's any kind of injury to either to yourself or to the baby, then you would sue for the injury, for the damage, for the harm. But if it was just early and there's no injury to anyone, then it probably doesn't make sense, right? Because it's not really an injury. And here's a question. Could you please make a video about cervical laminoplasty? My doctor recommended this surgery and I have back surgery recommended as well. It caused by a commercial van that rear-ended accident in New York City. Yeah, sure. I could do that. The best thing to do would be to just text me. I could just do a private consultation with you. It's confidential and it's attorney-client privilege, so no one knows about it. And then I could give you much more information. But if I did a verdict search video just about this cervical laminoplasty, I could do that. But the issue with that is when you do these videos, there's so many different verdicts. Some verdicts might be 200,000, other ones might be 2 million, and they're just all over the place. And all the cases are different. They're not your case. So, you know what I mean? It's not going to really be helpful, but I could do one. Okay. And then Lasito says, my coworker fell on me from a scaffold in New York. I have L3, L4, L5 posterior disc bulges abutting the nerve roots and a straightened lumbar lordosis through L5 with muscle spasms. And I was just standing up under the scaffold when he fell. I didn't contribute to the injury and my workplace is paying me with full liability indemnity payments. Proposed letter of conciliation has me at 100% disability and the IME doctor has me at 100% disability. Is that pretty good given what I've provided? Yeah, I mean, I'm sorry to hear that happen, but yeah, those are good cases because like if they fell, that means that, it wasn't safe. And if it's a 240 case, because if the accident happened due to the forces of gravity, usually that's 240, then, usually with the falling objects, it's a falling object that's being hoisted and secured, but maybe an object touched that other worker and the worker lost balance and the scaffold didn't have the proper safety causing that worker to fall and hit you. So I'd have to research that because usually it's a falling object, like an object that's being used in the construction. But I suppose a falling worker would qualify. Yeah, actually, a falling worker would qualify as well. And if you got injured from the falling worker, yeah, it would be like a strict liability. So the owner at the job site and the general contractor would be 100% liable. And then the injuries sound like serious injuries. And in labor law cases, the numbers are higher anyway. So you can go for lost wages. And, depending on what you end up doing, if you end up needing like surgery, but even if you just have physical therapy, they tend to be higher cases. So I think, it sounds like a very strong case. And then Darla says, hi, Mr. Arkady, I just saw you were online. Enjoy watching and listening to you. I sent you a text. Oh, okay. Yeah, absolutely. I'll take a look. I'll respond. Absolutely. Hope all is well. And yeah. But yeah, for Losito, just feel free to text me, same 347-566-9595. I could do a consult with you and answer all your questions. That's a good case. Hans says, hi, Arkady. And Truick says, I caught you at the perfect time. I'm a pretty popular YouTube for gaming. Oh, gaming. Gaming is good. Yeah. Hans says, what do you think if the lawyer says you did a good job in discovery? Do you think he's lying to make you feel better or telling the truth? And what are the good things when you do good in discovery? Well, I mean, I think the lawyer meant that you did a good job at your deposition, right? Because discovery is just basically obtaining information and providing information. So I don't think he's talking about documents, right? Like you did good by giving your medical records. No, right? Because you don't do that. The lawyer does that. So he must be talking about depositions. Like you did good in terms of being a witness, like answering questions. I think that's what he meant. And yeah, that's fine. I think that's fine. If I mean, I wouldn't know if he's lying or not. How would I, I don't think he should be. Why would he lie about that? If he thought that you didn't do a good job and you were a bad witness, you would probably say, you know what, I don't think it's like the best witness. The case might have issues. But if he's saying you did good, he's pretty confident in the case, most likely. And then Truick says, so basically I got hit by a guy with a 500, adding a spinal fusion. We'll have adjacent spine disease in like 20 years. The excess is 500. So should I just take this to trial and go for 4 million or just take one? Got the life care plan as well. Should I take it to trial or just take the 1 million limit? Well, no, I mean, look, if you can get more, if you feel like you can get more, it's a 500 policy and you have a spinal fusion. But the excess, so you're saying it's 500 with another 500, right? Excess. So the total is 1 million. So how are you going to get 4 then? You're saying if you open the policy or if you try to get them on bad faith? If it's only 1 million and you can take the full million, then you're taking everything there is. Then of course that's good. That's good. You should do that, I think. But I don't want to give you advice because without looking at the file, always best to speak to your lawyer. But generally, yeah, I mean, if that's all there is, but you always want to look and see, is there any other umbrella? Is there any other, excess or supplemental? And then let's do one more question because I got to run. But Carve Life says, in medical malpractice, once merit is established, how long does it take before the defendant is notified? Oh, yeah. So no, certificate of merit is just something that's like a requirement. So it's not about establishing it. It's just really a certificate of merit just means that your lawyer has consulted with a doctor and the doctor has confirmed that the case has merit, right? That they reviewed the medical records and they agree that this is a case, that the doctor's mistake caused injuries. So then at that point, you just file the lawsuit and it's the same as any case. So you file the lawsuit, it gets served on them, and then they have like 30 days to appear. So they get notified when you serve them. So if you file the lawsuit, let's say today, you serve them within, I don't know, a week, 2 weeks, whenever the process server serves them. And then they have 30 days to respond. So it's pretty straightforward. Okay, everyone. Thank you so much. Please like and subscribe to our channel. Let us know what questions you have. Let us know what videos you want to see. Our goal is helping serious injury victims and families. And let us know if we could help you. Here, I'll drop my number in the chat if you want to text me. I'm happy to schedule a consult call and answer your questions. And happy holidays, everyone. Happy Thanksgiving. Hope you're safe. All the best to you and your family, and the best of health, and all the best to everyone. Okay, everyone. Bye-bye. Have a great night.